I'm going to talk about the way in which the international protection of human rights has evolved in the last decades at two levels. First of all, at the level of the norms, of the legal norms that have recognized human rights, but also at the level of the mechanisms, at the level of the bodies that have been created to monitor the implementation of human rights. So once we've covered the evolution at the normative level, but also at the institutional level, we'll deal with some global obstacles, with some global challenges that these norms are facing and that these norms have to deal with. Well, international protection of human rights has developed significantly in the last decades, especially after the end of the Second World War. With the creation of the United Nations, this development consolidated and took high speed after these atrocities, after the atrocities committed during the Second World War. First, the United Nations Charter was adopted in the San Francisco Conference, where we can find some very strong references to the promotion and protection of human rights. First, the Preamble of the Universal Declaration of Human Rights refers to the faith in fundamental rights and human rights, in equality of men and women, and in the dignity and worth of the human being. It's a very significant proclamation, especially taking into account the context in which the United Nations Charter was adopted after the Second World War. Second, and as a continuation of this effort of the international community, on 10 December 1948, the Universal Declaration was adopted, a declaration in which the international community committed to promote and protect both civil and political rights and economic, social, and cultural rights. Well, these two documents establish the foundation of what we know today as international human rights law. These two documents, the United Nations Charter, the Constitutive Treaty of the United Nations, and the Universal Declaration of Human Rights, establish the legal parameter and the umbrella of this body of international law, and has been followed by a number of international treaties, specific treaties, that promote and protect specific rights. First of all, the so-called the two covenants. There is one covenant on economic, social, and cultural rights, and one covenant on civil and political rights. They are of a general nature because they cover human rights in general, the two categories of human rights. And then we also have specific treaties, like the one that prohibits the use of torture. We also have a convention on the rights of the child. We have a convention on the elimination of all forms of discrimination against women. We also have a convention on the rights of persons with disabilities, or the convention on disappearances. So there's a whole range of specific treaties that protect specific categories of people. So this is the way in which the legal sphere has developed, starting in 1945 and still continuing today. These legal frames create mechanisms, create bodies for the promotion and protection of human rights. First of all, the so-called the treaty bodies. These treaty bodies, also known as committees, they are created by the specific conventions, by the specific treaties. We have the Human Rights Committee, we have the UN Committee on Economic, Social, and Cultural Rights, the UN Committee Against Torture. So there are a number of committees with specific functions in the area of protection and promotion of human rights. These committees have a number of functions. I'm going to identify the three main functions in my view. First of all, they consider periodical reports submitted by states, and once they analyze, once they review these periodical reports, they issue recommendations to the state. Second, they also receive individual communications by human beings that consider that their rights have been violated, and they take these cases, they analyze these cases, and in the end they also issue recommendations to the member state. And last but not least, these committees can also issue general comments. These general comments are comments and interpretations on some specific provisions, some specific rights incorporated in these international treaties. Well, besides these treaty bodies, we also have the so-called special procedures. These special procedures were created by the former Human Rights Commission, UN Human Rights Commission, and these special procedures basically have two main tasks, two main functions. First of all, they investigate some phenomenon and of violations, of gross and systematic violations of human rights, and once they've made this investigation, they report. And they basically report to either to the Human Rights Commission, to the former Human Rights Commission, today the Human Rights Council, or to the General Assembly of the United Nations. But the main task, the main function is to investigate and to report. And then we also have the main political body is the former Human Rights Commission that was created in February 1946, but this commission worked for 60 years and then in 2006 was substituted by the current Human Rights Council. Well, the Human Rights Council has also a number of functions, but I would emphasize a new mechanism, a new procedure that was created in 2006, namely the UPR, the Universal Periodic Review. This Universal Periodic Review means that every member of the UN, so all states of the international community, have to go through a periodical review by the Council, and the Council monitors the way in which these states are realizing, are implementing the basic human rights. So these are the three main mechanisms: the UN treaty bodies on the one hand, the special procedures on the other, and then the current Human Rights Council. Of course, this is a significant development. There's a whole architecture for the promotion and protection of human rights, but of course there are some obstacles and some problems. First of all, the nature of the decisions. These decisions taken by these bodies are not binding. They're not legally binding. They're considered as recommendations, so they have moral and political force, but from a legal point of view, they're not fully binding. Second, there's also a lack of implementation mechanisms. These bodies lack the capacity and the mechanisms to monitor the way in which states are complying with their decisions. And the third obstacle has to do with the lack of time. These bodies of experts do not work full-time, they're not paid, and they work on specific sessions during the year, but this is not a full-time job, so the capacity that they have to monitor and to implement human rights is quite limited. Very much connected with this idea of the lack of implementation mechanisms is the fact that at universal level, there's no judicial body for the promotion and protection of human rights. While in the regional systems, we have the European Court of Human Rights, the African Court on Human and People's Rights, or the Inter-American Court of Human Rights, through courts, through judicial bodies that can issue binding decisions on states, that's not the case at universal level. At universal level, there's no World Court of Human Rights. There have been some proposals, there are some voices that are claiming for the creation of such a court, but still there's a lack of political will, and I'm a bit skeptical about the adoption of or the creation of a World Court of Human Rights in the near future. So this situation, both at the normative level and also at the implementation level, has to be analyzed in the framework of the current challenges that the international community, that the world is facing. And I would identify basically three main challenges that, in my view, can become significant obstacles for the promotion and protection of human rights. First, the emergence of illiberal regimes and populist regimes, not only in Europe but elsewhere. They're questioning the very core principles of international human rights law, and they're also limiting the space that civil society and the space that human rights NGOs have for the promotion and protection of human rights. They're also using migrants as scapegoats, and they're questioning the very foundations of liberal democracy and of the pillars, the essential pillars of human rights. Not only in Europe, once again, I'd like to emphasize. Well, the second challenge for human rights is the question of the adequate resources, the adequate economic resources that are necessary for the full implementation of human rights. In order to get these adequate resources, a tax policy, a tax justice is absolutely essential. In that sense, taxation is the most predictable, the most reliable, and the most sustainable source of public funding for the implementation of human rights, specifically economic, social, and cultural rights, but also civil and political rights. Well, today the situation as far as taxation is concerned is very worrying by a number of circumstances. First of all, many companies, and especially technological companies, are largely undertaxed, so they don't pay the taxes they should, and that's something that a number of reports have criticized. There are also a number of strategies for fiscal evasion, for fraud, and for corruption in connection with the payment of the taxes that we should pay. There's also the situation of fiscal havens, where rich people and big companies put their money to avoid being taxed. So these strategies for fiscal evasion basically put on the table the need of international cooperation for making those that have sufficient resources to pay the taxes they should. Because in the end, taxation has two main functions. First of all, it provides the necessary resources for the satisfaction and for the implementation and realization of human rights. But on the other hand, a taxation system can also have a redistributive effect, can be used to transfer income from one group to another, and especially to help those vulnerable groups to be in a better situation. And the last challenge has to do with the environment. Today, 23 September 2019, the UN is having a UN summit to deal with the global degradation of the environment, global warming, climate change. Well, this situation is also implying a huge risk for human rights of both individuals and groups and collectivities, because in the end, it's not only the rights of present generations, but also the rights of future generations that are at stake. So we should take it very seriously, because a human rights culture in which both rights and duties are complementary, this human rights culture has to take care of the environment and has to provide for the rights of future generations. I've identified the main challenges, but there's hope. There's hope because much has been achieved in the last 70 years. The Universal Declaration of Human Rights was a landmark document that has had an influence in the evolution of international human rights law. But a window of hope is opening when we see how young people are mobilizing for the protection of the environment, following the example of Greta Thunberg. And in many cities in Asia, in Africa, in the Americas, in New York, in Japan, young people especially, are mobilizing for the planet and for a future. So that's one sign of hope, and let's hope that this example is followed by many other examples and by many other people.